now. This is session 2 out of the 3 of SPHR, PHR certification preparation, an overview of the HR body of knowledge as defined by the Human Resource Certification Institute, which is the accreditation body for individuals in the HR profession. So today we're going to talk about a number of topics that you'll probably view as somewhat more hands-on than the subject matter we talked about last time. We'll start with the topic of selection and placement, sometimes more popularly known as hiring. So talk about the whole process of hiring. As far as law is concerned, when you make an employment decision with regard to an employee, it becomes a selection and placement decision. So not only upon initial hire, but also when you promote people, or alternatively, when you make employment decisions with regard to retain people in employment. The rules that we're going to talk about in just the next couple of minutes apply to all of those kinds of decisions. First of all, we have the ever-popular Title VII of the Civil Rights Act of 1964. It's applicable to employers that have 15 or more employees. It prohibits discrimination based on 5 grounds: race, sex, color, national origin, and religion. That law prohibits both direct discrimination, which is sometimes known as different treatment, in other words, holding men and women to different employment standards, or whites on whites to different employment standards. But it also prohibits indirect discrimination, even where there's no intent to discriminate. It's otherwise known as adverse impact discrimination. And you might get asked on the test about one of the hallmark decisions made by the U.S. Supreme Court with regard to Title VII, a case known as Griggs versus Duke Power Company. In a particular case was a situation where an employer had an educational attainment requirement for employment. In other words, they required people to have a high school education. And the Supreme Court of the United States, way back in 1971, found that to be unlawfully discriminatory for 2 reasons. The first reason was that the requirement to have a high school education was more difficult for blacks to satisfy than it was for whites. And secondly, the employer could not show any rational relationship between performing on the job and the possession of a high school education. In other words, they had people without high school educations that were performing the desired job acceptably, and that people with the desired education who were not performing acceptably. In other words, the possession of the criteria, in this case educational establishment, did nothing to predict success on the job. Secondly, we have something known as an executive order, Executive Order 11246, which originally issued by President Nixon back in the 70s. Executive Order 11246 is the authority for non-discrimination programs with federal contractors. So if you are a federal contractor, Executive Order 11246, which is administered by an agency known as the Office of Federal Contract Compliance Programs, have additional requirements over and above those that are expected of other employers. So just as an example, years ago, I asked to investigate an act or alleged act of discrimination that occurred on a military base. In this case, the Department of Defense got involved instead of the normal Equal Opportunity Commission. And the reason Department of Defense is because that particular restaurant was on a military base and operated under a contract, thereby subjecting that restaurant to the Office of Federal Contract Compliance as an oversight agency for compliance with non-discrimination rules. Under federal law, you have separate laws for a number of topics. One of those is the Age Discrimination in Employment Act. And unlike Montana law, ADEA applies only to some employers. From Title VII, ADEA applies only to employers that have 20 or more employees. And it only protects employees that are age 40 and above. And as we know, Montana law applies to all employers and to all ages. The law is much more restrictive than. The next is something called the Fair Credit Reporting Act. And the Fair Credit Reporting Act gets involved when employers go to information aggregators, what are otherwise known as credit reporting agencies. If you get information about a potential employee from a credit reporting agency, so that could be things like going online to publicrecords.com. It could be going to a private investigator for a criminal background check. Anything other than you personally contacting the source is covered by the Fair Credit Reporting Act. It sets up standards with regard to the procedure used to do background checks, and also sets up disclosure requirements that if an employer receives adverse information about a candidate or current employee, there's a step process that requires that they notice the employee of the adverse information and provide them certain information about their legal rights under the Fair Credit Reporting Act. The Rehab Act is from 1973, and it's a precursor to the Americans with Disabilities Act, but it only applies, as does Executive Order 11246, it only applies to federal contractors. The HRCA is the Reform and Control Act of 1986. That's the law that originally established the requirement for employers to complete the I-9 form that have to do at the point of employment. And while it's largely a process to determine whether or not individuals have lawful authorization to work in this country, it also had the effect of beefing up the national origin discrimination rules, because it's concerned that if employers were required to complete I-9 and they're fearful of being penalized for having certified somebody who wasn't a lawful alien, they might discriminate against people who looked foreign. So at the same time that they established the requirement to complete I-9, the HRCA also made changes to Title VII with regard to national origin discrimination. The Public Protection Act we don't deal with much in Montana, but as a federal law, the Polygraph Protection Act generally prohibits most employers from administering lie detector tests. There are a small group of employers that are exempt, which are federal and state and local governments. And among the employers who are covered, which would be primarily private sector employers, there's 3 exemptions that exist in the law in terms of when you are lawfully able to do polygraph tests. One of those is if an employer is investigating economic loss. In other words, if you suspect some employee of having stolen from you, the Polygraph Protection Act, the federal law, would authorize you to do a particular process of doing the mechanical lie detector test. On the other hand, law prohibits you from otherwise requiring people to participate in a polygraph test as a condition of employment or as a condition of obtaining employment. There's also an exception in that law for people who have access to controlled pharmaceuticals, such as people that work for drug companies and possibly people who work in nursing homes or hospitals. If you know what the UGESP are, have you ever heard of that, Marlena? UGESP stands for Uniform Guidelines on Employee Selection Procedures. So they're applicable to federal contractors, and they're also applicable to any employer covered by Title VII of the Civil Rights Act, which basically employers with 15 or more employees. What they do is they set up standards for quality of the process that you use to select people for jobs or promotions or retention and so on. What they do is they establish standards for validity and for reliability of the process. Validity is the concept that you're actually measuring what you think you're measuring. An example of questionable validity might be back in the old days before word processors became common, you could go to Skip's shop in Livingston at the job service, and you might well be given a typing test on an electric typewriter. But as you all know, the process of typing in an electric typewriter is a little different than typing on a word processor because you have to remember to hit the return button. So it's entirely possible that somebody that's subjected to that kind of test to predict who would be the best hire, who's been working with a word processor, would score lower than somebody who's been working with an electric typewriter recently, and thereby skewing the results. In that case, while there is some predictive ability of that electric typewriter to predict the ability to type, it's not as perfect as having tested them on an actual. That's what the job itself involves. So form guidelines are something that are predominantly tied to discrimination law, and if there's a violation of the UGESP, it's considered a violation of Title VII or alternative of Executive Order 11246. Describes what's called the Worker Adjustment and Retraining Notification Act, better known as the Plant Closing Law. And as a plant closing law, what it does is it requires notice when employers shut down a plant or have alternatively what's known as mass layoffs. And it generally requires at least 60 days notice of the shutdown before it can take effect. If you fail to do so, you can be on the hook for 60 days worth of benefits or possibly even 60 days worth of wages unless there's an intervening some form of an emergency. A refers to the Americans with Disabilities Act, and as you're all well aware, it requires that you make reasonable accommodation to an otherwise qualified person with a disability. Tort is the concept of a tort. A tort is when one party has an obligation to another party. An example might be if it snows and you go to shovel your walk at your business, you have an obligation to do a reasonably good job of that. And if you do an imperfect job and somebody suffers, like they slip and fall as a consequence, you might have a lawsuit against you. So when you're into the whole hiring process, there's a number of obligations that you might have with regard to applicants or employees, and your failure to carry those out could result in you being charged with a tort violation. And what's useful to know about torts is, in addition to make whole remedies, which is what you get civil violations, torts you can also get compensatory damages, punitive damages, and emotional distress damages. So torts can be quite more expensive than other forms of violations, which is why trial lawyers are often looking for a tort behind every trade. Is another law that most of you are aware of is reasonably new, and it gets involved in selection and placement from a perspective that you can't make hiring decisions based on family medical history information. So in other words, you couldn't decide to hire or not hire somebody because their relatives have poor health or good health. VA protects the employee if they personally have a health condition or a disability. VENA protects people when they have an unmanifested disability. In other words, it's in their genetic makeup, but it hasn't actually expressed itself at this point in time. So, well, with hiring, staffing in general, one of the concepts that you're going to run into is equal employment opportunity, and then a little bit differently, the concept of affirmative action. So to compare and contrast EEO and affirmative action, EEO might be, let's say that you have a foot race and everybody has the same opportunity to run the race on their individual qualifications. So it might be making sure that the path is acceptable for people and there's no artificial barriers for them to be successful. Affirmative action is remedial action legally, and remedial action is action that's taken because of past discrimination. So, for example, if I had two runners in my foot race, one of them could run from the starting point and had no encumbrance, and the other would put a 20-pound weight in their ankle at the beginning of the foot race, EEO would be removing the weight from their foot. Affirmative action would be trying to figure out where they would have been had that weight never been attached to them to begin with. So affirmative action is remedial, and the Supreme Court has weighed in with regard to affirmative action on a number of cases. And most of it's relatively old case law now, dates back to the late 70s or the early 80s. There's a case out of the University of California, Davis, that involved a person who was a candidate for the law school. The case is called Bakke versus University of California Regents. And Bakke had been an applicant in their desire to get more non-white students. The University of California had set up a quota system, and they had X positions for whites and X positions for non-whites. In his case, the quota for whites had already been used up, so that was an absolute bar to him being admitted to school. And what the Supreme Court ruled in the Bakke decision is, when you're dealing with affirmative action can be a factor in the final decision, but it can't be the factor. In other words, whatever you do with affirmative action cannot be an absolute bar to others. So you could have had, for example, a tiebreaker, but you can't have anything that functions as an absolute quota. We also had a case called Kaiser v. Steelworkers and a couple of others, but ultimately what the rule down to being is, in order to justify affirmative action, you have actual evidence of past discrimination. That actual evidence might be, for example, in the form of bad statistics. And to give you an example that was true years ago, knowledge was whether it's currently true or not. Way back when I used to be the affirmative action officer for the state of Montana, we had some law enforcement jobs. There's about 200 people in this particular field, and they were 100%. They went to the University of Montana for candidates because the university had a specific degree program that qualified people to do this particular job. Well, interestingly, 30% of the candidates, or 30% of the graduates in that degree field were female. Not a single one had ever made it through the hiring process. So in this particular case, the actual evidence of discrimination was gross disparity between the women present in the qualified labor force and the number that were actually employed. And so having bad statistics like that could be sufficient to justify an affirmative action plan. Secondly, affirmative action has to be temporary, can't forever. So it has to be remedial in nature, in other words, designed only to remedy the inequities caused by your past discrimination. In the same sense that if you steal from me and the court orders you to reimburse me, that's a remedial action. I only expect you to reimburse me for what you stole from me, not pay me forever. So, on the other hand, equal employment opportunity has no affirmative action component in that. EO, in my viewpoint, is simply making sure that there are no built-in headwinds, no built-in artificial barriers to people. Under EEO law, there are a number of what are referred to as protected classes. Can you mute your phone, please? Under EEO laws, which is Title VII of the Civil Rights Act, you have a variety of protected classes. Again, sex, color, national origin, and religion are covered under Title VII. Age is protected under the ADEA. The ADA, Americans with Disabilities Act, protects people age 40 and over. Also, the Pregnancy Discrimination Act and a couple of others. But ultimately, discrimination is defined as unjustifiable actions where people of protected classes are either overtly treated differently because of their membership in a protected class, or the net result of your action is to put individuals at a disadvantage. So if I wanted to say, if you want to work for Pasta Montana, you have to be at least 5'10" tall. I'm not overtly saying no women can be employed here, but that's pretty close to the net effect of that kind of a rule, given the disparity between the average male and the average female. Statistically, you would find that 45% of men are disqualified by a 5'9" or taller requirement, but 95% of women are. So that simple fact, plus presuming you can justify the requirements being predictive of success on the job, would cause it to be considered to be unlawful. And we have the uniform guidelines, which are pretty specific and pretty esoteric rules, and they are to implement the discrimination provisions. There's also a set of questions and answers that you can look at. If you know more about the uniform guidelines, just go to the website uniformguidelines.com, and you'll find two things there, one being the actual regulations and the other being the questions and answers that will help you understand what they mean. Flow is another concept that relates to EO and affirmative action. If you're subject to Title VII of the Civil Rights Act, in other words, if you have 15 or more employees, are required as a matter of law, and it actually comes from the Uniform Guidelines, to quote, make and maintain records to show the impact of your hiring procedures on protected class members. So what that means is you're supposed to have records that show who hired and who got hired and how far they made it through the hiring process. And if you are challenged with a failure to hire case, those kinds of records are commonly requested by the Human Rights Bureau or the EEOC. That you might run into. Recruiters, obviously, the process of creating a pool of hopefully qualified candidates for a job. Employees tend to compete with other organizations in something called the labor market. The labor market is simply those people who are in the geographical area from which you drop individuals for consideration for employment. So where I sit today, our labor market is roughly southern Lewis and Clark County, northern Broadwater County. Basically, it's the folks who live in the area where either in town or within a reasonable commuting distance and should be considered to be in contention for a position. You use labor market to describe the people with the requisite qualifications for your specific job. Look, it is the source. The term applicant pool are the people who have actually satisfied whatever your requirements are for being considered for hire. And as far as EEO rules are concerned, anyone who has completed whatever your requirements are is considered to be an applicant. So if, for example, you say, I must have an application form and a resume, people who complete those two steps are legally considered to be applicants. But if you accept application from somebody who's not submitted both of those, then what you do is actually what your real applicant pool is. That term becomes important, particularly in things like metrics that we'll talk about, and it becomes important for purposes of the applicant flow statistics that we just briefly discussed as well. There are a lot of potential source of employees beyond the traditional applicant pool that's created by going out and recruiting in the newspaper or otherwise sending something to job service or a private employment agency. So alternate places where employers can find people, independent contractors often convert and become employees of the entity that they were an independent contractor to. The flip side is a lot of them became employees the day they came to work and you believed them to be independent contractors because you didn't play the independent contractor game properly. Workers, which are people who are hired for a contingency, and the term contingent worker is often used here as well, but a contingent worker is somebody who's hired for a specific reason or a specific period of time. So in other words, a contingency like you have an absent employee, or you have an employee that's on military leave or maternity leave or whatever it may happen to be, triggers the need for a worker. But in many, many cases, those temporary workers go on to be regular employees, and employers can certainly recruit from that pool of people. Employee leasing describes a similar but a little different kind of a scenario. At least temporary workers are brought in to fill vacancies in specific areas. Employee leasing, on the other hand, is where all or nearly all of the workers of a particular organization are technically on the payroll of another entity, and other entity is responsible for hiring, discipline, payroll, benefits, and those sorts of things. So if XYZ company and I'm missing a specific kind of worker because I only use them temporarily for a season, I'm called a temp agency. If I just don't want to deal with the hassle of being an employer, I would call what in Montana at least is known as a professional employer organization, better known as a PEO. So while they're similar and they're both forms of contingent workers, temporaries and leased employees legally are somewhat different. You can certainly look to people to promote from within, and there's two concepts. One is called posting, and the other term is called bidding. Posting is where the employer puts up some sort of an announcement and says, we're looking for people to fill this position. Bidding is somewhat more competitive, typically based on something like seniority-based bidding, where the most senior person is awarded the promotion, or some other criteria that might be specified by policy or something like by labor agreement. You have former workers. Interestingly, a very significant percentage of workers who left for greener pastures end up finding out those pastures are no greener. And there's a lot of workers, a lot of companies that actually have formal programs to reach out to those people. They get a fairly significant portion of those people to come back to work because there's a couple of CPA organizations that do that. About 6 months after somebody left, they basically say, interested in coming back? And if so, we'll do the following for you. We'll give credit for time previously served, give you an advance thing. And so what they do is they bring people back, already know the process, already know the policies, that are more experienced and trained, somebody just off the street, and typically they can do it for the cost of a stamp and a piece of letter. So it's a very good source of workers. Public employment agencies are owned and paid for by your FUTA taxes under what's called the Wagner-Pizer Act. Placement agencies are places like organizations that just do IT jobs or just do accounting jobs. School college recruitment is a source of people, particularly when you're looking for people with specific academic qualification. So you would typically contact the placement office at the school, and they would refer people to you. All kinds of media. You have newspapers, you have radio, television, whatnot. Professional and trade associations, many of them have the opportunity, they have newsletters that go out to their members, and so what they do is they will disseminate your job announcement to people who are in a specific trade or profession. So, for example, we've recruited for folks that are experienced purchasing agents, and we went to the Association of Purchasing Agents because we already had people that had the qualifications we were looking for and asked them to disseminate it to their membership. Private employment agencies would be situations like Jim and I and asking them to help you find somebody. Executive search firms is very similar. Computer databases might exist that have various kinds of names on them, and finally internet job sites, things like monster.com or other kinds of things. Those are all places where employers are now going for employees. And it's temporarily not true. In the long haul, in the United States, we don't have enough people to maintain the labor force because we haven't had enough kids in our families. So what you see is a slowly decreasing pool of people from which to draw, and people are having to start to look at some of these alternative sources because putting an ad in the newspaper is not producing the number of qualified applicants. There's a number of metrics that are associated with recruitment. One of them is referred to as selection rate, which is simply defined as the number hired the number of candidates in the applicant pool. If you hire 2 and there's 10 people in the pool, you have a 20% selection rate. That can be used to look at the effectiveness of your recruitment. And, if you, for example, find that that percentage is inordinately low, that might suggest that your recruitment is not working properly because you're not getting qualified people into your pool. The E ratio is something that's used in applicant flow. It's comparison of applicants at one stage of a process to the next. So, for example, how many people made it through the review of the resume? How many people, what percentage of the people made it through the oral interview? And those, again, are used to measure the effectiveness of various portions of the process. The cost to hire is used a lot, particularly by entrepreneurs and CFOs. You look at the direct cost, which is what it costs me to put the job on Monster, what did it cost me to put an ad in the newspaper, plus the indirect costs, which might be like supervisory time, training time, those sorts of things. Again, applicant flow is a pretty technical concept, but what you do is you look at relative pass rates at each step of the process. If you want more information about the 4/5 rule, email. I have a separate document that shows you examples and explains what the 4/5 rule is all about. But ultimately what it says is there's a certain deviation from a norm that's allowed in anything more than basically a 20% deviation between the pass rates of one group and another is presumed to be discriminatory unless you have something that shows that it isn't. Selection as compared to recruitment, selection is the process of choosing individuals who have the qualifications you're looking for. The term selection criteria describes the particular things that you're looking for, and often under the concept of selection criteria, we have a variety of predictors that are used. For example, we may say that people with a degree in accounting are likely to be successful in this particular job. The degree is not really a requirement. The degree is a predictor of success. So what we found over time is people with X years of experience or people that have done certain kinds of tasks are likely to be successful in our job, and the term used to describe those things are predictors. Validity and reliability in selection, again, that comes from the Uniform Guidelines on Employee Selection Procedures that I've already discussed to a certain extent already. Employment testing and screening, there's a variety of different things that can be used, but all of them are referred to in the law as tests. And a test is defined as anything upon which you make a decision. So a test can be an application form, it can be a psychological exam, it can be a work sample, like typing tests or work samples, it can be a polygraph or an honesty test where those are allowed by law. Could be a background check, could be drug or alcohol or genetic testing, again, where those are allowed. But all of these kinds of things, I think the message of this particular slide is all of these kinds of techniques for predicting success on the job are all covered by the Uniform Guidelines on Employee Selection Procedures. Interviews, very popular, something like 97% of all hiring decisions involve some form of an interview, typically face-to-face, occasionally over the telephone or something, but very popular, even though it has very low predictive ability. There's terms that are used with interviews. One is called structured interviews. So a structured interview is where the person who's conducting an interview has pre-established questions that are asked of all candidates in the same sequence. So you always ask question 1 before 2, you don't change the order. You actually back away from your questions. One thing you're going to find is in some cases, one question will suggest the answer to a later question if people are actually paying attention. So that's one of the reasons why you want to do things in the same sequence. Here in Montana, we actually have a Montana Supreme Court decision that mandates you do the same thing. We had a case back in 1983 where different people asked different questions of different candidates for the same job. And when that got challenged, the employer said, well, we hired the best person. The Supreme Court of the state of Montana basically said, how would you know? People didn't ask the same questions. You have no common base of knowledge for who's the best qualified. They're called situational interviews, and that's otherwise known as hypothetical questions. That's where you inquire as how a candidate might handle a particular situation. So a situational interview question might be something like, assume that you were in this scenario, what might you do? A behavioral interview question is similar except that it asks people to decide what did they do as opposed to what might they do. So ask for people to actually talk about examples from their training or experience that shows that they've handled specific issues in the past. Obviously, behavioral interviews generally have higher validity than situational because there's a difference between people who know how to act and people who actually behave the way that they know they should act. So behavioral is always better than situational. Directive interviews use questions from which you develop other questions. So depending on how persons respond to the first question, you then ask follow-up questions that might be different person to person. The term stress interviews refers to the process of putting people under artificial stress or anxiety to see how they respond. I remember a number of years ago we were recruiting for an auditor that had the responsibility of going into huge multinational companies to conduct audits and be up against some of the highest stress attorneys and CFOs in the world. So in the interview, we artificially put them under stress to see how they would respond to that because it was a real part of the world that they would be living in where they could be hired. The term panel interviews refers to the use of groups of people that will participate simultaneously in an interview as distinguished from having just one person do an interview. The concept of panel interviews is that having a variety of perspectives will help balance or cancel out biases that individual panel members have. Another advantage is that it brings a wider breadth of expertise to the panel to help evaluate the responses that you got from individuals. Some problems you run into in interviews, poor questions don't produce the true answer. So if your question is ambiguous and there's 2 or 3 ways to potentially legitimately respond to it and they don't give you the one you were looking for, that's not necessarily predictive of the fact that they don't know the answer. It's just predictive of the fact that your answer was unclear that you were looking for. So because of that, for example, here, I often, when we're going to do interview questions, find somebody who's not been involved in the process, show them the questions, and ask them to tell me what they think the question is asking about. And they basically come away from that process clueless. I would have never guessed from that question where you're looking for that kind of information that maybe it's time to go back and rewrite the questions. You also have to be careful about questions that violate the law or count privacy. For example, do you have relatives that have ever had cancer? Would be a violation of GINA. Or are you married? Would be a violation of the marital status provisions of Montana Human Rights Act. Other problems include making snap judgments based on your first impression that might be negative or undeservedly positive, allowing bias or unrelated information to cloud your evaluation of the candidate. Topic: training and development in the workforce. So training is defined as the either on or off the job process. So on the job training is where you actually perform the work and learn by performing it. Off job might be classroom training or other places where they do it away from the actual physical work site. But the process of training is where people acquire skills or knowledge that help them achieve certain goals that are important to the employer. The process of training is often split between HR and management. HR often has the responsibility to help identify the training needs, but it's management. Management might observe an employee who's performing poorly and identify that training is necessary to get that person up to standard. HR often tracks training, but so does management. So management might help deliver training, HR might help deliver it, or might contract with others to come and produce it, or you might send people out to vocational technical school or university or other types of providers of training. But training typically follows what's known as a training needs assessment. So a needs assessment is a multi-step process which considers, first of all, where the organization is headed. So if you know that you're going to start producing a new kind of widget, you might have to train people up so that they're capable of producing that particular widget. You on the training needs assessment have to determine what the priorities are, which things have to come first, which can be deferred, or necessarily have to be deferred until their information has been presented. You'll, in training needs assessment, deal with trying to decide what the objective is. So are you trying to improve quality, trying to improve quantity, timing, cost savings? Because often said, if you don't know where you're headed, it's awfully difficult to chart a path to get there. So knowing what your end result is part of the training needs assessment process. And then finally, how are we going to cause it to happen? Will it be OJT? Will it be classroom training, apprenticeship training, or whatever it may happen to be? Various kinds of training exist. They're always on the test. The first is apprenticeship training or on-the-job training, OJT. It's defined as training where the person learning works under the direct supervision of experienced workers. So apprenticeship training typically involves working at a somewhat lower level, but under tremendously increased supervision compared to what might be true of a journey-level worker. The career development refers to lifelong learning and might be somewhat more general than task-specific training that might otherwise be the case. So initially, an employer probably wants to make sure that you know how to make the widgets it sells. After that, they might invest in you just being a more capable person by giving you training in things like time management or how to do good business meetings or those sorts of things. Orientation training is defined as the kind of training that gets people up to speed and introduces them to the rules of the game, so in other words, the policies and procedures of the organization, and introduces them to the tasks of the job, the safety process, make sure that they don't become injured, to expectations, quality, quantity, those sorts of things, and often should introduce them to working with the workers so they know who to go to if they need assistance, what the chain of command is, that sort of thing. Last vestibule training has been on both tests that I've taken, and vestibule training is basically a simulation kind of thing. Instead of being on the work floor, you're out in the vestibule. What you're doing is you're doing the simulation of making a loaf of bread or a simulation of other tasks that are part of the job. Cooperative training, otherwise known as internships, is often where there's some sort of a linkage between an employer and somebody like a university or vocational school, where people come in to learn how to apply information that they were exposed to in their more academic part of their training process. Classroom or conference training typically is the kind of thing where you go off to a SHRM conference or one of GI's training classes and you learn about things away from the workplace. Distance learning, or otherwise known as computed instruction, is becoming increasingly popular, and that's where you sit at a computer station and go through some form of training. Unlike exactly what we're doing right now, where you're sitting in Sydney, Montana, and Livingston, and elsewhere around the state, being introduced to subject matter that's useful for you to be aware of. The term assessment center refers to a situation you often hear of things like in basket, that sort of thing. But an assessment center is where you put somebody into a simulated environment where they're required to do things like make decisions based on things that are in their in baskets. So there might be a stack of memos that describe simulated circumstances, and your requirement is to drop the letter in response or to make a decision with regard to how to handle something. That assessment center typically monitors what you do and compares it to the expected norm, and then where you fall short, provides for training to get you up to speed. Psychology of learning. Getting esoteric now. The basic concept is learning takes place where information is, number one, received, number two, understood, and number three, internalized. But there's several steps to make that occur, to make learning occur. First is you have to create an incentive or an intent to learn. If people don't care, then the process of training is not going to be successful. Learning is not going to occur. So you have to first create the incentive. And incentive can be the opportunity to work at a higher level at work. It can be personal growth. It can be a monetary reward. There's a number of reasons that could, in different individuals, create that intention to learn. There's called Gestalt learning, and it refers to an overall view of learning instead of the immediate specifics. I doubt that that particular term will be on the test, but it is listed as part of the body of knowledge. Reinforcement is the concept that the love effect, which states that people repeat responses that result in positive reward and avoid those types of circumstances that have negative consequences. So if you can show how the learning process is a positive thing, chances are people will learn. Immediate confirmation as opposed to deferred confirmation, immediate is where they get an immediate reward. On the term test, it used to be that when you took the test, you would have to wait 4 to 6 weeks to see how you did. Now, at the instant that you answer the final question, it instantaneously gives you confirmation as to whether you passed or not. That would be an example of immediate confirmation. Practice can be active. In other words, as we're training you, you can try to actually get out the task yourself, or practice can be spaced over days, or can be masked. We can do it all at one time. But transfer training refers to, and have you ever known anybody, for example, that's a degree in your field, but is clueless, they can't apply the knowledge? So transfer training refers to the ability to transfer what they've learned to the actual job. And people are very good at that. Others are really good at learning it, but can't necessarily apply the concept. There are some laws that affect training. Again, Title VII, the various discrimination laws, National Labor Relations Act, OSHA, Occupational Safety and Health Act, actually has some required training requirements, but most of the laws that apply to training speak to the results of the decision to train or not train. So it's going to look at things like, do you offer whites and non-whites equal opportunity to learn? You not, however, have different passing scores for whites and non-whites, or different passing scores for men and women. But there are a whole lot of laws, but most of what exists are either collective bargaining-related laws or discrimination-related laws. In the training and development area, there's typically a four-step process. We talked about doing a training needs assessment that basically compares need to where you currently are, the status quo. Once you've determined where you are versus where you want to be, you conduct what amounts to a gap analysis. The concept of gap analysis is look at how you get from where you are to where you want to be, how to bridge the gap, if you will. You then get into the curriculum design phase, and that's where you design and identify how you're going to actually cause the need learning to occur. You're going to bring in an expert, you're going to do OJT. The step is actually conducting the training. The final step is measuring whether or not the training that you actually delivered caused the desired change to occur. So basically, very similar to the needs assessment, you go back and compare where you're at to where you need to be. And hopefully, having followed the steps, you'll find that that gap is now somewhat smaller because training had some form of positive effect. But the terms read are the terms you should know for the test. Compensation is another area. Compensation and benefits, a lot of these laws address those two areas equally. Some of the laws that you deal with that have to do with employee compensation. As a federal contractor, you're very likely subject to either the Davis-Bacon Act or the Service Contract Act. Davis-Bacon Act applies to people who engage in contracts to build buildings or highways or power dams or that sort of thing. So it's construction related. The Service Contract Act applies to companies that provide services to the federal government that are similar to those that might otherwise be provided by federal employee. For example, here on the temp service that I own here at West Staff, we're covered often by the Service Contract Act if we provide employees to, say, the Forest Service or the Bureau of Reclamation or whatever. Both of those laws have what's known as prevailing wage requirements. So what they do is they say, if you're going to do work for the federal government, you need to pay wages that are comparable to what those people would earn were they working for the federal government or if they were in a normal civilian type of economy. So typically there's what are called prevailing wage rates. So for a given kind of a worker, if you go to the U.S. Department of Labor's website, you can look up and it's done geographically. For example, in the state of Montana, there's, I think, 13 districts, but you can look up what you would have to pay a per if you're doing a construction project at Malmstrom Air Force Base. And it'll tell you what wages have to be. It'll also tell you what the benefits that you must offer, or alternatively pay a certain dollar amount for liquidated value of benefits like insurance and holidays if you don't offer those benefits. So basically, Davis-Bacon and Service Contract Act set minimum pay and minimum benefits for workers that perform services for the federal government. The Copeland anti-kickback law has to do with competitive bidding and not colluding with another organization to set pay and benefits. Equal Pay Act, Title VII of the Civil Rights Act, again, that same group of non-discrimination laws say you can't pay people differently based on gender, based on race, based on other protected class bases. The government has wage garnishment laws, and garnishment is where an individual owes money to some creditor, and the creditor has gone to court and gotten a court order requiring the employer to deduct a payment to that creditor from paychecks. And what the wage garnishment laws do is they speak to how much of a paycheck can be subject to garnishment. In other words, you can't throw the person out of their home. You can't deny them sufficient money to buy food in order to settle their debts. So it's a law that attempts to find a balance between money owed to somebody and their wages and their living expenses. We talked earlier about the Fair Credit Reporting Act. ERISA stands for the Employee Retirement Income Security Act, and in the 1970s era law that deals with things like pension plans and other welfare benefits that employers may offer, and it requires that they be fiduciarily funded, properly funded to make sure that the money's there when people get eligible to retire, that sets up standards for things like the relationship between employers and employees with regard to 401k plans and a variety of other things. But ERISA sets national standards and actually preempts state law. States may not have laws with regard to retirement benefits. COBRA, the federal law, stands for the Consolidated Omnibus Budget Reconciliation Act of 1986. And COBRA was the law that set up the requirement for employers that have 20 or more employees that have group health insurance, make sure that they have the right to continue to participate in that health insurance plan, depending on the reason they left employment, for up to 36 months after the loss of eligibility. So workers typically get 18 months benefits, and beneficiaries and kids and spouses and whatnot can have up to 36 months. Workers' compensation is a required insurance program to protect employees from injury, hurt, and employment, and it provides both lost wages benefits and payment of medical benefits for covered injuries, and in some jurisdictions, for things like occupational diseases, like black lung disease, that might make it difficult for somebody in the coal mining industry to continue working. Social Security gets involved with employee compensation because, like work comp, it's a mandatory deduction from pay, but it also provides what amounts to a long-term disability plan to employees that have been out of work for 6 months or longer. The Fair Standards Act is one that you're probably all too familiar with. It's one that establishes topics as diverse as minimum hourly pay rate, overtime. It also includes some things that might surprise you. For example, the FLSA includes the requirement that was added about 2.5 years ago to provide nursing mothers with a place to express breast milk while at work. That's all part of the Fair Labor Standards Act. The Medical Leave Act is also part of the FLSA ultimately. So the laws that deal with employee compensation, there's no tax laws that deal with employee compensation. That has something called Circular E, and just think of E for employment, and otherwise known as Publication 15, and there's really 3 parts to it, 15, 15A, and 15B. But those 3 things collectively make up what's called Circular E, and they're the things that define the taxability and deductibility from taxes of various benefit programs. So they help define what is and what isn't considered wages, what is and what isn't considered benefits. So as an example, a question not long ago where somebody said, my business is located way out of town. We're at least a half an hour drive from town. We offer our employees lunch and we don't charge them for lunch. Is that taxable benefit? So the answer to that question is in Circular E. And the answer is not. If it's primarily for the benefit of the employer, it is not considered a taxable benefit. So a lot of questions come up. So in Circular E, Publication 15 on your desk is probably a smart thing to do. Other things that you run into that have tax implications are various kinds of retirement plans. So IRS, through, and also what's called the Pension Benefit Guarantee Agency, establish minimum standards for participation, both on who's eligible and how much does the employer have to fund. There are about a half dozen different types of retirement plans. Most of them do have a couple of things in common. They have what are referred to as non-discrimination benefits. Remember that most of these things, most of the retirement plans are offered on a non-taxable basis. So because there's a tax advantage to using these plans, the IRS does not allow employers to restrict who's eligible. If you restricted something only to highly compensated employees in the organization were allowed to have retirement, let's say, that would be considered to be discriminatory and would then subject that payment to tax. So if you're the owner and you only give yourself retirement and don't give it to other eligible employees, there can be an excise tax levied on that. That's how they keep employers from doing it. It's a pretty substantial excise tax. So he also addresses wages and benefits. There's very specific rules with regard to what's considered wages versus what isn't. Also, know what FASB stands for, and FASB is a Financial Accounting Standards Board. What it does is it addresses and sets standards for how things like stock options are treated for purposes of profit and expense reporting. So all employers have to do it the same way under federal income tax. Like wage and hour, just like everything else, there are a lot of rules that apply to wage and hour law. So some of the things that we have to deal with is the Fair Labor Standards Act, and like most federal laws, it applies selectively. So the Labor Standards Act applies, first of all, where revenues of the organization exceed $500,000. And you'll often hear 2 words used. One is enterprise, the other word is establishment. Enterprise refers to the totality of the organization. and all of its branches and locations. The term establishment refers to the individual location. So you might be, let's say, the hospital in Sydney, and you might have a branch location up, let's say, in Play. Together, that's considered the enterprise. Each location is considered the establishment. So some of these rules apply enterprise-wide, some are establishment-based rules. So if the enterprise does over $500,000 a year, or alternatively, if it doesn't do that, if any individual employee is involved in interstate commerce, those people are subject to the Fair Labor Standards Act. But pretty difficult for employees not to be involved in interstate commerce anymore. So you might have situations such as an employee who works at the Made in Montana store in Lewistown, Montana, sells only things that were made in Montana and sells them only to people who live in Montana. But as they swipe the credit card through the credit card machine, they become an employee that's involved in interstate commerce, because the other end of that financial transaction is almost surely out of state. Additionally, if you're a governmental entity, a hospital, a nursing home, a laundry, or a school, you're covered by the Fair Labor Standards Act, regardless of the annual revenues of the organization. And as mentioned a couple of minutes ago, when we talk about the Fair Labor Standards Act, it includes child labor, family and medical leave, minimum wage, overtime, and what are known as wage payment laws, which we'll talk about in just a couple of minutes. So the U.S. Department of Labor Wage and Hour Division enforces all of those subject matters. So if somebody accuses you of not paying overtime, you're going to speak to the same compliance officer as if somebody accuses you of having an underage employee or failing to provide family and medical leave to somebody who believes that they're eligible for it. So some of the terms that you run into in wage and hour law: exempt and non-exempt. Exempt refers to being exempt from the minimum wage and overtime requirements of wage and hour law, in this case, the Fair Labor Standards Act. Non-exempt is sort of a double negative. What it refers to as being eligible for overtime and minimum wage. When you think of exempt, a lot of people think of what are referred to as the white-collar exemptions, but altogether, there are probably something approaching 50 different types of exemptions provided by law. So, for example, people who are over-the-road truck drivers can be exempt from overtime, but they're not exempt from minimum wage. It's important to remember that some people, the word exempt means exempt from both minimum wage and overtime. With others, it means exempt only from overtime. So if you're a farm and ranch worker, you have minimum wage, but you don't have to get overtime. If you're somebody that works as a referee for a high school football, there's partial exemption for them. Time refers to the practice of, if somebody works excess time in one work week, have them take the time off in a different work week. The flex time refers to if somebody works extra on a given day during the work week, they take time off in the same work week. Flex time is lawful, comp time is not lawful for non-exempt employees. And whatever it's worth, has never been lawful, even though it's commonly done by employers. So it is not lawful for you to provide comp time to a non-exempt employee. Somebody works 42 hours in one of a 2-week pay period and 30 hours in the next week, you still owe them 2 hours of overtime. Excuse me just a second. refers to the concept of tracking the time that people are engaged in activities that are considered time worked. If you're interested in that subject, look at the set of federal regulations. Just type into Google 29 CFR, which stands for Code of Federal Regulations 785. The 75 regs define what activities are time worked. So that's where you find rules related to things like whether or not participation in training is time worked, whether or not travel to and from work is time worked, about coffee breaks and meal periods and working without permission and all those sorts of topics. So if something is considered to be time worked, it then demands that it be paid for at a rate that is at least minimum wage, and unless the people are exempt, requires overtime if the total time worked exceeds 40 hours. There is no requirement under federal law to compensate people extra for time worked on holidays, weekends, overs in a day, or anything other than time worked in excess of 40 hours in a work week. The term market pricing as a compensation term refers to the relationship between pay that you pay people and what the competitors that you compete with in the labor force, the relevant labor force, pay people. So market pricing is the practice of paying your employees what the Joneses pay other people who do similar work in the same labor market. Rarely do we care what they pay across the country, but there might be some jobs, like if you're recruiting for the CEO of a hospital, where your labor force that you're considering people from is truly regional or even national, that pricing might look at national wages, but mostly we're looking at local or regional within the state. The terms you run into is people who are red circled and people who are green circled. The concept of red circled means you have somebody who's currently being paid a rate that's above the going rate for a particular job. It can happen for a variety of reasons. Maybe you hired them because of previous experience and you promised them a rate that's higher than they would have earned had they not had that prior experience. And so you describe those people as red circled. People who are paid below where they should be are described as green circled. Red won't get you into legal trouble, green circled can, because green circled can end up being a violation of the Federal Equal Pay Act. The term pay compression describes when you have pay ranges. So for example, maybe you have pay range 4, pay range 5, and pay range 6. And over time, as you do increases, so originally there was, let's say, 5% difference between grade 9 pay and grade 10 pay. If you do equal dollar increases, in other words, if you say everybody gets a $50 a month raise, what you're going to find is over time, what would be 5% difference may be 3% difference now. To maintain and avoid pay compression is to use percentage increases and just pick a number and say this one's 5% more than that. But organizations, the state of Montana being a good example, when money's tight and they can't do a full cost of living, they say, okay, we'll give everybody $100 a month. And before long, you find the supervisors making virtually the same thing as the workers. Very little difference between them. The term comp ratio refers to where people are paid compared to typically the market pay rate or midpoint of a range. So if you say the midpoint for the range of people who make widgets is $20 an hour, and this particular employee is paid 19, you divide one into the other and you come up with they're at 95% of the midpoint, so their comp ratio is described as 95. Or if somebody's making $2, you say they have a comp ratio of 110 because they're making 110% of the midpoint range. These come up when you're constructing or administering particularly pay ranges that are based on grades and steps, which are fairly common. When you pay systems, you often run into probably two different kinds of pay systems, and then a third that's a hybrid of the two. One referred to as rank and position systems, and that's where you pay people according to the work that they perform, as distinguished from the qualifications of the incumbent. You have a rank and position system, and you have two people employed as janitors. They both get paid the same, regardless of the fact that one has an 8th grade education and the other has a PhD. If you have a rank and person system, you pay people based on personal attributes. Rank and person, you see that in the military, you see it in education, and a couple other industries. For example, in the military, you get paid to be a sergeant or a lieutenant or a colonel, not based on what you're actually assigned to do. Similarly, if you're a school teacher, you get paid based on whether you have a BA or a master's, primarily and only secondarily how classroom is that you're teaching or factors like that. But in practice, we have something referred to as a hybrid system, and in a pay system that's a hybrid, you have people grouped into job classes on rank and position sorts of things. So, for example, all people who work as civil engineers are grouped together, all people who work as HR people are grouped together and put in a certain class. But with the class, there's variable pay based on personal factors, in other words, rank and person factors. So even though both people are in the same pay range, where an individual worker is predominantly dependent on personal factors like what their level of performance, what longevity do they have. So you might have as much as 20, 30, 40% difference even though they're in the same pay range. So hybrid is by far the most common, but fundamentally it's an adaptation of the two basic kinds of systems. Systems can have a variety of goals. It can be the ability to attract and retain qualified staff. If you tell me that's your goal, surely what you're saying is your compensation system needs to know what other people who you're in competition with pay people to do a certain job, because if you're paying way below market, it's going to be very difficult to attract and retain staff. External pay equity is really the same thing, just described a little differently. If you tell me you want to pay for performance, obviously that means your compensation system has to have some way of measuring people, in other words, some sort of a performance appraisal system that measures performance against goals or against other employees. If you tell me that you want to facilitate or reward long-term employment, which is the easiest to measure because all you have to do is measure how long they've been with you, which is why you see that used in so many systems, is because it's relatively uncontroversial and it's really easy to measure, but it's also the least predictive of who your good employees are. Because the simple fact that people have been around a long time is not necessarily correlated with their level of performance. This one you notice is in red. Equal pay for equal work is a federal requirement, and there's also one in Montana for whatever it's worth. But equal pay for equal work law says you pay people the same, except that You may pay them differently based on things like productivity, based on qualifications, based on length of experience, or any other legitimate job factor. So if you don't have to pay a man and a woman differently, in other words, has a PhD in the relevant field, another one has a B in that field. If you don't have something like that, then you probably should be paying them the same. The concept of work of comparable value exists in the HR field, but has never been adopted as a requirement of law, even though there is a brief period of time back in the 1980s when it was very popular. There's a case called the Gunther case out of Denver, where some nurses that worked in a hospital found out that the people who mowed the lawn at the hospital got paid more than the nurses who were inside saving lives. That began the concept of work of comparable value. So comparing a yard worker to a nurse isn't going to come out in equal pay for equal work because they do such dissimilar work. But the argument was saving lives is inherently more valuable than cutting the grass is, so we should get paid more. But again, it's never gotten to be mainstream other than in a couple of disparate cases. The goal is to maintain purchasing power. So if somebody was around in the late 70s when we were having 20 to 25% annual inflation in the United States, if you didn't get a 22 to 25% raise every year, you were losing purchasing power. You had to work more hours to buy that pair of shoes or to buy that automobile. So typically, if you're going to have as a goal of your compensation system the ability for employees to maintain purchasing power, that means you have to have some measure, which is generally known as cost of living adjustments based on the cost of living index published by the Bureau of Labor Statistics. So they're all common goals that you see are frequently but not universally present in compensation systems. A concept that you have in compensation systems is base building versus non-base building. So some components of compensation are added to somebody's base pay on a permanent basis. So an example might be cost of living. Once the living is awarded, it's part of your pay permanently. So that's said to be base building. It increases your base compensation. Non-building compensation discusses things that you have to go out and constantly re-earn, such as bonuses, such as commissions. So you might get them one pay period, but you don't automatically get them the next pay period unless you go out and re-earn them. So most pay systems have a little bit of both. A lot of salespeople, for example, have base plus commission. So the base building, the commission is non-base building. Child are part of the Fair Labor Standards Act. So under the child labor provisions of law, the general rules are people who are 18 or older can perform any job for unlimited hours. There are some exceptions to that. For example, in some states, people have to be 21 to be employed as a bartender. In some, if you're a commercial driver, federal law requires you to be 21. But in the absence of a real job-specific statute that requires people to be older, the general rule is people who are 18 can do anything. People who are 16 or 17 can do anything except the 17 categories of work are considered to be especially hazardous to youth. They include things like working in butcher shops, working in construction, working in mining where you work with explosives. Among other things, operation of a motor vehicle is considered to be especially hazardous. So they can do anything except those hazardous occupations at 16, and they can do it for unlimited hours. For 14 or 15 are presumed to be second and students first, so they can work only outside of school hours in non-hazardous jobs. And there are limits, as you can see on the slide, as to what time of day they can work and for how many hours they can work. And you'll also notice that those rules differ depending on whether school is in session, and a presumption that school is in session from Labor Day through June 1st. So from Labor Day to June 1st, they can't work after 7 p.m. After that, then they can work till 9 p.m. There's big factors that affect compensation. I think we all know what inflation is. It's the cost of a given item goes up based on too many people to buy the same thing. So the cost raises until the supply matches the demand. Interest rates can certainly drive compensation. For example, here in the state of Montana, understanding that retirement is part of compensation, there's probably 20 bills in the legislature having to do with changing the retirement plan for government employees. And the reason for that is because interest rates over the last 4 years have been so low that the people who invest money for the state have not kept up with the increased cost, because a normal 10 or 12% return has been minimized and we just aren't making money. So it has a direct effect on compensation. Competition can certainly affect compensation. If you're dealing with a smaller share of the pie, there's probably less revenue, probably less profit, less money to distribute in the form of competition. Economic growth, or alternatively recession or depression. The term recession defines situations where the growth is impeded, but there still is growth. So, for example, normally in the United States, we see anywhere from 2 to 5% annual economic growth. If, let's say, 3% is normal and we're getting 0.5%, that would be recession. We're not growing as fast. Depression is where there's actually negative growth, so where we might be shrinking the size of the economy. So we've been in recession for the last 5 or 6 years. We've probably been in depression at least 1, maybe 2 of those years. Investments, value of stock can have an impact. If you look at a lot of the very highly compensated employees around the country, a lot of their pay comes in the form of stock. So if the stock is not worth anything, so you work for Facebook and last week it was worth $400 a share, this week it's worth $10, that's only going to have an impact on what the employees who are working for you are going to expect. Government or foundation funding availability. One of the individuals on the call today works for a nonprofit, and I suspect she could talk eloquently about the impact of the cutback in governmental funding of very otherwise useful programs. And an awful lot of places are suffering, which first means employees don't get raises, and in some cases employees actually get decreases in pay because of the lack of funding from associations or places like the Pell Foundation or whatever it happens to be. Common types. We have base pay, which describes where typically the base building concept. Base pay is what you get regardless. You can also get differential pay. Differential pay is what you get when certain special conditions are true. So differential pay often is associated with if you have to work the graveyard shift, well, 50 cents an hour extra for the hardship of that. It can also be if we make you go work in another area, we pay extra pay to offset the cost of living in a high-cost area. Incentive pay is where we tie compensation to the achievement of some sort of objective. It could be an individual kind of a incentive pay. It can be set up for a team or group that might have to work together to make something happen, or it can be across the entire organization. But the questions for incentive pay is you have to make sure that the incentive does not work at cross purposes with your organizational culture. So in other words, if you pay solely based on the number of digits, it's real important to you that quality be there. Be sensitive to the fact that reimbursing people for producing high volume might end up in conflict with your organizational culture to provide high quality of that particular unit. So make sure you take steps to protect the organization's cultural values. Certainly to make sure the incentives don't bankrupt you, you have the ability to pay the incentives. They're directly tied to the desired performance. So if your goal is to cause new customers to come to us, make sure that the way you structure the incentive pay actually makes that occur, and if that doesn't occur, they don't get the pay. You also make sure the organizational conditions are examined. Things can come and go. For example, it was only a couple, 3 years ago when a lot of people were talking about hiring bonuses. 3 years after the crash, nobody was talking about hiring bonuses. People were talking about laying people off. So things can change very, very quickly. Piece is where you pay people based on the number of completed work units. For example, for every widget that you do, for every square inch of advertising you sell, we will pay you X. So pay is directly related to the units of whatever you're selling have. Straight commission is one way to pay people, but remember, for a lot of people, paying people straight commission does not release you from the obligation to pay minimum wage. So if you have a straight commission employee, unless it qualifies an outside salesperson, you need to, on a weekly basis, ensure that commission earned equals or exceeds whatever the minimum wage would be times the number of hours that they work. Some people get paid a base salary plus a commission, at least in part to make sure that we don't end up with any kind of minimum wage violation. Bonuses are typically non-base building, using the definition I gave you a couple of slides back, and are usually paid one time. Some employers spread bonuses out over a month or even over a quarter, but more commonly they're paid on a one-time basis, like it's Christmas or something along those lines. Other kinds of incentives. Gain sharing is a term used to describe a situation where there's greater than expected profit. So if we're expecting $1 million worth of profit and we get $2 million, the term sharing might describe we get that excess and we divide it based on some formula with the employee to help create that excess profit. Sharing is a term that describes simply divvying up the profits. So, for example, here in this office, we have a formula that says based on sales, employees who help produce it get X% of that profit generated. So the goal is to encourage people to create more profits so they can in turn get a greater share. Ops otherwise known as employee stock ownership plans, is where you create a business model that as people work for you, part of the compensation package is stock ownership. So you might give them a share of stock in lieu of $20 or $50 or whatever the value of the stock is, and it's based on the idea that people who are owners are going to be more committed to the success of the organization than people who are just employees. So particularly if you're going to do ESOPs, there's some things you need to do from a tax perspective, including how do you value the stock, because it is considered compensable income in some cases. Job analysis. Is defined as a systematic determination of relative worth. So job analysis is how we rank people into pay, middle pay, low pay, that sort of thing. Otherwise, this is known as job classification. So there's a variety of ways that you can do it. You can use what's called a whole job ranking method. You subjectively rank jobs based on some sort of criteria like worth or difficulty. So that you might say, as we were talking about a few minutes ago, just inherently somebody who's a registered nurse is more valuable than somebody who's outside mowing the lawn. So in our job classification system, we would rank the nurse higher than the person who's mowing the lawn. That's a subjective type of ranking system. Qualification method is where you look at specific attributes of the job. So specific attributes of the job might be, do they supervise, yes or no? If they supervise, how many people do they supervise? What's the difficulty of the task performed? What's the nature of the work hardships? Do they have to work in a dangerous circumstance, or is it in a relatively comfortable internal office kind of an environment? A point that takes that one step further and actually assigns points to each of the factors. So the goal there is you take the classification factors and you take a job description or you take information from an interview and you actually score jobs, and the resulting point totals are used to rank jobs from high to low. And obviously, as you rank jobs from high to low, the assigned to each job goes from high to low as well. Better jobs are jobs that are common enough that they can be compared with other organizations. Interestingly, there actually are about 46 benchmark kinds of accountant jobs that are used by the U.S. Department of Labor. So when you say, I have an accountant one, there is standard job description that all employers can look at. There's, for example, 6 different levels of accountants, and you can say, yours is a level 2, and that allows you to compare organization to organization much better than you could simply looking at job titles. So benchmark jobs are the ones that you use external comparison. So again, if you're, let's say, the city of Helena, you might have, let's say, a police patrol officer might be a benchmark job. Other cities have, and that makes a pretty easy comparison because most police patrol officers do relatively the same thing. And you can use that to establish your comparability to other types of employers that you might be in competition with. Pricing, in other words, what do you pay people to do certain work, be based on internal or external equity. So internal is where you use a job classification and you allocate people to certain pay range based on similarities to other jobs. So under an internal equity system, you determine that, for example, everybody who's a fresh out of school with a pre-professional degree gets put at pay grade 12. So if you follow that kind of a system, it doesn't make any difference whether they're fresh out of let's say medical school or fresh out of engineering school or architectural school, you treat them all alike because as far as you're concerned, they're all equal for pay purposes. Annual equity is where you say, what do the Joneses pay registered nurses? You're going to find situations where, based on my experience, most employers want to do both internal and external equity, but in some cases it's very difficult because the labor market doesn't do internal equity very well. So, for example, in my personal view, the qualifications to be a physical therapist are very similar to the qualifications to be a registered nurse. But I think as our representative today from the Sydney Healthcare Center will tell you, PTs typically make $10 or $12 an hour more than registered nurses. Giving them equal based on their qualifications would be internal equity. I can guarantee you if you insist on that, you're not going to employ any physical therapist because they're not going to work for you for that same rate. So sometimes the two are in tension with each other. When we do salary pricing, to the degree that external equity is important, we do some form of a salary survey that we use to benchmark what the pay should be for that police patrol officer or that physical therapist. There's a bunch of sources that are already published for that kind of information, readily available online. If you're not familiar with it, I'll give you two sources that you can look at. One of them is called ourfactsyourfuture.org. That's Montana Bureau of Labor Statistics. Again, our facts, O-U-R, facts, yourfuture.org. Or you can just do a bls.gov and then links back to each state. The other where it's all assembled rather nicely is a website called onetonline.org, onetonline.org, which is U.S. Department of Labor job description engine, which contains a lot of information to help you with job pricing, because it'll show you what people pay in your location as well as your state as well as nationally for relatively 465 standard occupations that exist. Once you collect external information, you typically have something called a pay line, which connects the midpoint or the salary parity points for each job grade. Like that would be on. But maturity curve probably would be. Maturity curve is a term that describes a relationship between pay and experience. So in other words, one point on the curve would be, does somebody make, if they have 1 year of experience, what do they make if they have 5 years of experience? What do they make if they have 10 years of experience? So connect those points, you have what's known as a maturity curve. And benefit programs fall into a couple of categories. One are those that are legally required, things like work comp, unemployment. You have benefit programs that are considered income replacement. So it falls into that category. So if you lose income because you're sick, sick leave steps in and compensates you that period of time. You can have benefit programs that are insurance or income protection things like health insurance, life insurance. You can have deferred pay kinds of programs. You can have benefits that provide pay for time not worked, as known as vacation or holidays. You can pay or at least unpaid time off for things like family and medical leave, maternity leave, military leave, and so on. You have cafeteria plans. The term cafeteria plan describes a scenario where there's a variety of benefits available to people, and they basically choose those that are of value to them personally. So, for example, if you have a younger employee who's married and has a kid, the things that are important to that person probably are low out-of-pocket expense if they incur a health care sort of situation. Somebody that's an older worker may be able to have a plan where there's a higher out-of-pocket because their income is greater, but may prefer to have more in the way of a contribution to a retirement plan. So you often hear these referred to as Section 125 plans. That refers to the section of the Internal Revenue Code that allows employers to provide cafeteria plan benefits. So the requirement for the employer is that the employer say, you got $1,000 to spend it however you like. If you want more health insurance, if you want to provide health insurance for your family, you can do that. If you prefer less health insurance, more retirement, child care, whatever the particular benefits are that might be in the cafeteria, each employee can decide what works for them best. And then finally, we have employee recognition and award programs. Recognition might be for time worked, it might be for good performance, it might be employee of this quarter, employee of the month, might be a special parking place right outside the door, all kinds of things. But often those are, number one, no cost associated or very minimal costs associated with them. They tend to have more effect in terms of job satisfaction than a lot of the benefits you pay a whole lot more for. Third, employers have to provide Social Security and Medicare. That's a shared cost between the employer and the employee. Workers' compensation in most states. Some states don't require it of everybody. For example, in Florida, you only have to have a work comp plan if you have 4 or more employees. So it's basically state created. Federal and state unemployment insurance is a national program, and that's paid 100% at the employer cost. You might see a reference there's, I think, 3 states that do this, California being one of them. They have a state disability program that's collected by the Unemployment Insurance Division in California. So a lot of people think of it as unemployment insurance, and the employee pays like 0.25% of their wages for it, but is not unemployment. Unemployment by law is 100% employer provided. Some employers are subject to COBRA, FMLA, USERA, and whatnot, but whether or not you're covered, COBRA, for example, is dependent on the number of employees. FMLA is dependent on the number of employees. USERA, which is the law that deals with time off for people in the military, is based on whether or not you have any employees who are in the military. Election leave is kind of state by state. Jury leave is state by state and dependent on summons. If you're a federal contractor, as we talked about, there are additional benefits such as Davis-Bacon Act or Service Contract Act require review. There are laws out there, mostly federal, that require that you pay unpaid or that you provide unpaid time off. Maternity leave comes from a 1978 law called the Pregnancy Act Amendments of 1978. Under federal law, maternity leave is considered to be equivalent to other temporary disabilities and are supposed to be treated the same. Duty is covered by a law called the Jury Imprisonment Act. It basically requires employees provide leave without pay during the period of jury duty unless excused by the judge. You don't have to pay them. There are some implications for the pay of exempt employees, but as a time off, if a woman is eligible for maternity leave, it's mandatory leave. The same thing with jury duty. Military leave, those mentioned USERA, which stands for Uniformed Services, Employment and Reemployment Rights Act. There's 5 criteria that if those are satisfied, and those are if they had a civilian job, gave notice that they were leaving, not been gone for more than 5 years, except certain exemptions exist there, then released from service under honorable conditions, and report back to work in a timely manner. If those are true, the employer must reemploy the person after the completion of military duty. What she is, the law protects both short-term leaves, like is typical of people in the reserves or the guard. So people are gone for less than 31 days, like they're gone to weekend drill because they're in the Air Guard. They're gone to summer cruises because they're in the Navy Reserve. They simply report back to work after the completion of military duty, plus travel time, plus 8 hours of rest, and they have to be put back to work right away. People who are absent for longer periods of time have a period of time to reapply for their job, but the employer must reinstate them as soon as they can following the notice that the people intend to return. Again, depending on how long they're gone, whether it's 1 to 6 months, 6 months or more, there's different periods of time that they have to reapply for their jobs. Medicare is a term that describes a health care benefit that has an emphasis on primary care and prevention. There are several kinds of managed care programs. HMO is where services are provided for fixed periods on a prepaid basis. So in other words, you pay people to keep you healthy, and you go in and they do various services to maintain your health. PO is a preferred provider organization. So that's where your healthcare provider contracts with a certain group of doctors and hospitals and clinics and whatnot to provide services at a typically discounted rate. And typically with a PPO kind of an insurance plan, you have the terms in-network and out-of-network. You go to an in-network, there's either no cost or there's minimal cost. If you go to somebody with which they don't have a contract, typically there's much higher out-of-pocket costs for the insured employee. A point of service plan is similar to PPO, but it reimburses the medical providers that actually perform the services. There's a few terms that describe cost containment strategies used by either employers or insurance companies. One is co-payment. So in other words, if you go to the doctor, it might cost you $20. And the idea of that is to discourage people from going unless they really are ill. Because if there's no consequences to the person using the service, chances are they will overuse the service, and that drives up the cost. So by requiring people to pay a portion of the cost, that number one reduces the cost to the plan and discourages unnecessary use. Utilization reviews are conducted by providers to determine the cost of various things are and what's necessary and what's not necessary, and all usually results in what are considered to be the going rates for different kinds of services, which establish what the usual customary and reasonable rates are that the insurance company uses to reimburse people. So if the UCR for particular service is $50 and you go to the Cadillac doctor and it costs you $200, they're going to probably reimburse you based on the $50. Programs are attempts by employers. It could be smoking cessation, it could be weight reduction, other kinds of things where they try to make people healthy, given that so many diseases these days are lifestyle caused types of ailments, and by doing so cut the cost of the healthcare benefit that's provided to people. Retirement programs with several terms. RIS I mentioned earlier is the Employee Retirement Income Security Act from 1974. It's the one that sets up rules for private pensions, for funding of the rules, and protection And if a company goes under, it sets up the Pension Guarantee Act, sets up a federal agency that makes sure you get your pension. Contributory is where the employer puts dollars into your retirement. Non-contributory is where it's 100% employee money. The contribution is where the employer commits to put in X dollars during a period of time. Defined benefit is where the employer guarantees a certain retirement amount. Very, very few places do defined benefits anymore. And even the state of Montana, which has a defined benefit plan, that you get X percent of your salary based on the years of service, is rapidly moving away from it because it becomes an actuarial nightmare, because right now where the income produced by the retirement system investments low, now have a multi-billion-dollar unfunded liability that we have to satisfy. With a defined contribution plan, you don't have those issues. They simply say, we'll put $100 into your plan. Whatever it's worth when you retire is whatever it's worth. And that's what probably 90% of employers do now, is defined contribution. Portability refers to the concept of, so you were XYZ and you have a pension plan. If that pension plan is portable, when you get and move over to ABC Corporation, you can take the plan with you, and the new employer, if it's contributory, can make contributions into the same plan. 4Ks tend to be portable. SEPs tend not to be. A couple other types exist out there, may or may not be portable. Vesting rights refers to the right to receive benefits from a program. And under ERISA, you have to vest in longer than 5 years. What that means is, if I hire a young man, comes to work for me, I make retirement contributions. If that person leaves in 5 years or less, and let's assume that I'm using 5 years for my vesting, if he leaves prior to 5 years, she's not considered to have any right to receive benefits from the plan. Some use partial vesting, like 20% at 1 year, 40% at 2 years, and whatnot. So if they leave, but when they get vested, they have full right to receive whatever retirement benefits that the plan allows. You have IRA kinds of plans, traditional and Roth. The difference between a traditional and a Roth plan is, in a traditional plan, you put money in on a tax-free basis, but when you draw the money out, you have to pay taxes on it. With a plan, you put already taxed money in, and when you draw it out, the principal is not taxable. With a 401k plan, another option that's for private sector. If you work, let's say, for a university, the university public sector variant of that's called a 403b. We have KEO plans, mostly for self-employed individuals. Here in our office, we have a SEP plan. SEP stands for Simplified Employee Pension. For example, are 100% contributory. Employees may not put money into the plan. SEP plans are just another form of a retirement plan. All kinds of optional benefits that people provide for their employees. If you want to see something interesting, go to the Google website, click on the link about working for Google, and look at the services that they provide and the benefits they provide for their employees, and you will get a glimpse of what the new economy thinks is appropriate. They have everything from an on-site dentist, an on-site physician, a cleaning wall, consignor services. Consignor services refer to, you don't have time to get your spouse a Christmas gift, all you do is call the consignor, they go out and buy it for you. So they take care of a lot of those things that keep you away from work. If you look at Fortune 500 companies, over half of them have consignor services now. transportation subsidies, there can be carpool, all kinds of things depending on the nature of the business. You can have flex plans, cafeteria plans. I think we've talked about that. Flexible spending accounts allow employees to buy specific things that meet their personal needs. So, we're 6 minutes over, but that's the subject matter I wanted to cover today. So this is your opportunity. If you have questions, you want to talk about things, Skip can turn your microphone back on. Kim, you can turn yours on if you like. So, for any comments or questions?
Head pounding. Good job, though. Thank you very much.
Okay. How about Marlena said that her microphone isn't working. So you can type in the chat box if you want, along with Michelle. Any comments or questions?
I can't think of anything, Jim. Great.
Okay. Anybody else? Dan? From Marlena, she says nothing new. Okay, thank you, Marlena, for participating. Probably Wednesday of next week, just like I did this week, I'll send out the link for the webinar and the PowerPoint for the last part of the session. If any of you would like some sort of completion certificate for SHRM or other continuing ed, just email me and we'd be happy to send it to you after the completion of the final workshop. So we'll see you next Thursday, 1:30, same time, but a different web address and a different participation. Thanks for participating. Bye-bye.
Thank you, Jim.